from California to Florida, and I thank you for your attention and look forward to answering your questions.
Thanks to both of you. Now we have 7-minute rounds. This is fine. FBI emails and other records to the public regarding Arctic Frost, the FBI's case against Trump. Those records show that Antitrust Trump FBI agent Thibault drafted, opened, and advanced the information that became the basis of Jack Smith's electoral case. The records further show that the work was done in violation of FBI rules. The government is supposed to produce impeachment evidence to defense counsels. So, did the government produce emails and records between Thibault and his team of agents to defense counsel, including the ones that I recently made public?
No, Senator.
Okay. You represented President Trump against both Jack Smith's lawfare cases. During the course of those cases, defense counsel raised issues involving DOJ and prosecutorial misconduct. Beyond that, which is public already, are you able to share with this committee additional examples of alleged Justice Department misconduct?
Thank you, Chairman. Yes, for sure. Two things come to mind. The first, and a lot of this actually is public. If you look very long and hard, it just never reported. The first is when President Trump was indicted in Florida first, the prosecutors in that case initially asked the court to not allow President Trump, the defendant in that case, to see the documents that he was charged with, okay, to see the evidence against him. The initial submission said they didn't think that the former president of the United States had a right to see the evidence against him. That's something that even terrorists who are charged often get to see, at least to some extent. Secondly, 3 months later, when President Trump was indicted in D.C., the prosecutors in that case asked the judge to start a trial December 11th of the same year, notwithstanding the fact that Jack Smith knew that he was producing over 11 terabytes of discovery to President Trump and the defendants. He also knew that President Trump was going to be on a trial in New York, a civil trial brought by the AG in New York for much of the fall, and that he already had a trial scheduled in Manhattan to start in the early spring. He also knew that Judge Cannon had already scheduled an evidentiary hearing the same day in Florida that they wanted the trial to start in D.C. Notwithstanding all that, that was their position. And Chairman, the frustration, and if I'm frustrated, I continue to be frustrated, is that the Department of Justice knew that that was happening. Nobody stopped it. Nobody stepped in and said, hey, that's not the way we do things at the Department of Justice. They just let Jack Smith do it. There are other examples. When the Supreme Court decided the immunity decision on July 1st, Jack Smith went right back to the grand jury, removed almost nothing from the indictment, and filed another charge. Department of Justice stood by and let that happen. That I think was a gross miscarriage of justice, Chairman. Later on in September, once again, they filed a brief that has never been filed in any case in United States criminal Department of Justice history. They just filed something. There was no motion pending. They knew it was a month and a half before the election, and so they filed a 170-something page brief that had no basis in the federal rules of criminal procedure. Apparently, they got permission or clearance from the Department of Justice to do that. So those are the two examples that always come to mind when asked about what happened, and to this day, I think that was a travesty of justice.
Ms. Slater, so I can get to a couple questions to you, answer this first one fairly short, although it's important for another longer answer. If confirmed, what will be your top priority in the Antitrust Division?
Thank you, Senator. As the President said, the task is to apply the antitrust laws vigorously and fairly with clear rules of the road for all.
I'm very concerned about the rising costs of prescription drugs. I believe consolidation in the healthcare industry and anti-competitive practices by both brand and generic drug companies, as well as by pharmacy benefit managers, contribute to these high costs. I hope I can count on you to address the anti-competitive practices of these industries. The three biggest companies have 85%, and most of them are owned by insurance companies. So it seems to me there's something very anti-competitive there. I'm not going to ask you for a commitment, but I'm going to ask you to look at that, and that you'll take companies to take steps to make sure that those rules are abided, the antitrust rules are abided by. I'd like to get back to Mr. Blanche. The New York Times said many people in the legal community ask, quote, why would he ever take that case, meaning the Trump case, end of quote. And we know that you suffered, you got kicked out of your law firm, that's what I understand. What did you learn from your representation of President Trump?
Well, Chairman, representing President Trump was the greatest job I've ever had. I think if I'm confirmed, my new job will surpass it, but it was the greatest job I ever had. It was an honor, and I learned a ton. It opened my eyes, for sure, to what happens when politics takes the place of justice. And both you and the ranking member talked about this, and I couldn't agree more that politics should never play a part in the Department of Justice. And I saw with my own eyes in Manhattan, with the Manhattan case, I saw it in the Georgia case, I saw it in both Jack Smith's prosecutions, I saw it in elected officials trying to keep President Trump off the ballot. It opened my eyes to something that I hadn't seen when I was just a prosecutor in New York trying to put gang members in jail.
Thank you both.